Namaskar. In the earlier video, we discussed about Central Civil Services conduct rules. Some parts we have discussed. Today we are going to continue with the next part. That we are continuing now with the rule number 3116. Up to 15 we have discussed. Another about 6-7 rules. I think 22 or something. 22. So afterwards the rules will be various specific things. Now it's all general related things. Anyway, these are all very important. Once this is over, the rules on financial matters, rules on marriage related things, and annual property returns, and many such things. All those things now we will see one by one. But today we are going to see the continuation of rule number 3.1 of 16, sub rule 16. Let us see. Every government servant shall at all times make choices, take decisions, and make recommendations on merit alone. So you take it, there will be many ways to do things. So we have to see the best thing based on merit. There is no scope for any other things. So merit alone. So when you take a decision or when you put up for a recommendation, the merit of the case have to be discussed. With that only, we can proceed further. And the government servant shall act with fairness. Fairness is nothing but honest. And impartiality, this we have already discussed, so it is stressed in this rule also. And not discriminate against anyone. There cannot be any biased approach against anyone, discrimination against anyone, particularly the poor. When we see the poor, we have to be more considerate also, and also the underprivileged sections of the society, because it is our duty to uplift the poor and the underprivileged people. The government servant shall refrain from doing anything which is or may be contrary to any law, rules, regulations, and established practices. It is for everybody, even people also have to follow the rules, follow the law. So the government servant has got more responsibility on that. So we have to refrain from doing anything which is against the rules, which is against the law or regulations or the established practices. So we have to avoid that. If we do that, we will be in trouble unnecessarily. The government servant shall maintain discipline in the discharge of his duties. When we do our duties, we have to maintain our discipline also. That is very important. The context is important because discipline has to be ensured. And be liable to implement the lawful orders duly communicated to him. That is, our duties are all, which is already defined, but higher authorities will say do this or that, but that order which is lawfully communicated, lawful orders. Orders cannot be unlawful. If some unlawful things are told, if some officer say no, you go and beat him, no, it is unlawful. So, but the officer says something which is lawful and it is communicated duly. What is meant by duly? It is given in writing, by mail, or any sort of communication, not oral, necessarily not oral. So when the orders are communicated duly, in the sense by letter, by order, or any form of written communications, or through email, or something like that, except oral communication. So that we have to implement. Only thing is we have to see whether this order, the instruction is lawful. If it is unlawful, you can always say, as per this rule, this is all wrong or this is against the law. You can write back in the order itself. Now, next point. Oral instruction we'll discuss slightly in the next slide. Before that, every government servant shall maintain confidentiality in the performance of his official duties. as required by any law for the time being in force. That means which is in vogue at the time of our working. Normally, Official Secrets Act, it comes only for the classified information, defense, security, foreign relations, and such things. Very, very cabinet notes. They are all confidential or secret or top secret, as may be classified. Okay, normally secret and the top secret will not come below deputy secretary level. Below deputy secretary level, confidential. At the most, I think secret also will not come. Confidential can come. So those cases cannot be discussed outside. We have to maintain confidentiality. Other than that, so what are those confidential things? We will list out. But all other things, transparency has to be maintained, which we have discussed in the last video. It should be open. People should not hide anything. Now, these confidential things relating to, suppose an information which, if you disclose, may prejudicially affect the sovereignty and integrity of India. That means the India's authority and India's integrity may be affected if you release that information. Yes, you can't discuss, you can't talk to anybody except your higher authorities with a file only. There is no personal thing also in that. And the information, if it is disclosed, may affect the security of the state, strategic, scientific, or economic interest of the state, friendly relations with foreign countries, or lead to incitement of an offense or illegal or unlawful gain to any person can never be disclosed. If such information is held by you in the process of your work, you should keep confidentially only. You can't discuss with anybody except those who are signing in the papers. With them as a formal discussion, you can always discuss. Not for others. Even within the department also, if somebody is not concerned with that particular subject or file, who is not going to see the file, you don't need to, you cannot, not just no, don't need to discuss, you cannot discuss. So confidentiality has to be maintained on all these accounts. Every government servant shall perform and discharge his duties with the highest degree of professionalism. That is perfection, correctness, in a standard manner. It has to be done. And dedication, because it is, we are paid for it. We earn because of the work. So we have to work dedicatedly only. Dedication to the best of one's ability. So here you have to see the best of one's ability. So it differs. But the maximum possible, it is relative theory, but still dedication must be there. Okay, now rule 3.1 is over. Rule 3.2. Rule 3.2. Now, oral instruction, all those things will come here. Every government servant holding a supervisory post shall take all possible steps to ensure the integrity and devotion to duty of all government servants for the time being under his control and authority. Suppose take one section officer or one under secretary, one deputy director, some supervisor, under him 5 people, 10 people, 15, 20, any number. It is the responsibility of that supervisory officer to ensure that all his people under his control at that time are honest, their integrity is impeccable, and they are devoted to duty. This has to be ensured by the supervisory officer also. If somebody doesn't listen, naturally he will take action. He will put up for necessary action. That is why now first we were talking about individual's responsibility. Now the supervisors, the head of the office or the any controlling officer, how they have to control. They have to ensure all these contacts. No government servant shall, in the performance of his official duties or in the exercise of powers conferred on him act otherwise than in his best judgment, except when he is acting under the direction of his official superior. What does it mean? Suppose you let us think of one our our situation. Assuming that some snake comes, you try to drive that away with a stick or something. You don't expect somebody's help, or if you are afraid, you run away from the house and call the uh, snake charmer or whoever it is. So you don't wait for somebody's. The best judgment is you decide to safeguard your children. You take them out or keep them safely and try to drive the snake. That is your best judgment. Suppose if you are afraid, you can't do that. You don't have that courage to drive that away. Yeah, you try to keep the children safe and then try to call the snake charmer. This is the best judgment. Given the situation, this is what you can do. Like that in office, the best judgment should also be within the rules. That is very important. Okay, what is the exception? You might feel this is the correct action, but your superior authority gives in writing that do this. And that is also as per the rule only. Yes, as ordered by the, as directed by the, whatever authority. You do accordingly. You record that and do it because there is an order. The direction must be in formal communication. Formal communication can be email, can be letter or order or note or anything. So it should be verifiable. So oral instruction cannot be verified. So that is one thing. Now the direction of the official superior shall ordinarily be in writing. What is shall ordinary? Normally they have to give in writing. Suppose there is an urgency, senior secretary level office or ministers or some senior officers who doesn't have time to write now. Yeah, they can tell orally, but that should be followed by written instruction. So the direction of the official superior shall ordinarily be in writing. Oral direction to subordinate shall be avoided as far as possible. As it's so it means they can give, but followed by written communication, written confirmation. Otherwise, oral instruction has got no value. Where the issue of oral instruction or oral direction becomes unavoidable. Yes, it happens. Senior officer, they may not have time to get it typed or prepared. They can say, and followed by written direction. That is very important. So when the issue of oral direction becomes unavoidable, the official superior shall confirm it in writing immediately thereafter. It is the responsibility of the higher authority. What if the higher authority doesn't follow with the next direction? Oral direction. Yeah, the government servant who has received oral direction from his official superior shall seek confirmation of the same in writing as early as possible. How do you say? You say, suppose you are given direction by your director, and there is no written communication immediately thereafter. You have to take action. So you prepare a note, director, administration, or whichever director, as directed as follows. You write whatever he has done. It is submitted that to whatever you want to do as per the direction of uh, the director. You say submitted for kind confirmation oblique approval. You send back the file to him. He has to sign. If he doesn't sign, see, he is not confirm his oral instruction. No need to implement such thing because you will be responsible when oral instruction is not recorded and countersigned by the officers. So you will become responsible. We will not do. In my experience, I thought I can give my experience while discussing these rules and all. Okay, I'll not quote the officers, but I worked in NIC. When I was working as joint director in headquarters, there was one new methodology for review was directed by our head of the department. It was good for the department's approach to select the best eligible officers for promotion. But unfortunately, in the promotion policy, this particular methodology was not notified. So we said it's the best way to select or give promotion for the people who deserve. We will do one thing, we will submit a proposal to ministry, because this promotion policy was issued with the approval of appointment committee of the cabinet. Okay, the methodology of review can be, my view was like that, can be defined by the ministry with the approval of the minister in charge. Since it is a cabinet approval thing, I felt the file may not be the methodology. If you want to change the methodology of review, it may not go back to ACC, was my view. But in any case, we have to submit to the ministry for approval. We will do it on priority, I said. My head of department was a bit angry. He was slightly angry and started questioning me why you are negative. I'm not negative, sir. We'll do it. No, review time is very less. We can't send the file. We can't afford to send the file to ministry. So no, competent authority is at the minimum it is ministry only, and they have to take a call whether they will decide or they will take approval of ACC. In my view, ministry can approve it, but we have no power to change the modality of review and all, sir. So we will take approval. No, you put up just up submitted for approval of competent authority. I will sign and send back. With that, you do it. I said competent authority is vested with ministry. If I don't say, tomorrow I will be in trouble. This is not correct, sir. We will set the file. I will take the file personally, I was trying to say, but he was not listening. Finally, I told the SOE, she was also in the meeting. I told her, yes, I won't mention the name. You put up as directed by. You mention our officer's name. The file is submitted like this, you see. Whatever he has directed, you write, and then he was stunned. There was no answer. Then slowly, in the discussion itself, he diluted, and the proposal itself was shelved. That was not my intention. My intention was we'll do, but we'll take approval of ministry and then do. At times it happens. Honestly, he wanted to select best people for promotion, which is right. But we have to see whether he has the power. If he doesn't have the power, he has to obtain it from the higher authorities. Otherwise, people can go to court and say, under what authority you have introduced these new norms and other things and that. They can question. So entire scenario will become vitiated. All the reviews will be stopped by the court, which he was not ready to accept at that point of time. What I'm trying to say is, you follow the rule, but be firm when you feel that it is not within our competency to do the things. You try to put across in writing in a polite manner, nothing wrong. So that is not revolt, that is not insubordination. It is only where, because they are all senior officers, they may not have sufficient, of course, work experience or the intricacies of rules. We'll have to bring it to their knowledge. This is the rule, sir. We'll have to do like that. Okay, with this, uh, that problem was solved. Now, let us continue this conduct rules things in part 3. Till then, thank you.